What are the mandatory abuse reporting requirements under M.G.L. C. 111, Section 72G? When abuse in a nursing home goes unreported, the harm can continue and families may be left searching for answers. Massachusetts General Laws Chapter 111, Section 72G requires certain paid caregivers in long-term care facilities and home health, homemaker, or hospice settings to immediately report suspected abuse, mistreatment, neglect, or misappropriation of property to the Massachusetts Department of Public Health. This law is part of the Massachusetts Patient Abuse Statute, which spans sections 72F through 72L of Chapter 111. The reporting duty begins when a covered reporter has reasonable cause to believe abuse or neglect occurred. The law does not require proof before a report is made. Covered mandatory reporters include physicians, medical interns, residents, physician assistants, registered nurses, licensed practical nurses, nurse aides, orderlies, home health aides, hospice workers, homemakers, administrators, responsible persons at care facilities, medical examiners, coroners, dentists, optometrists, opticians, chiropractors, podiatrists, police officers, social workers, speech pathologists, audiologists, pharmacists, physical therapists, occupational therapists, and health officers. The law applies specifically to long-term care facilities, home health agencies, homemaker agencies, and hospice programs, including hospice services operated by hospitals. Even people who are not mandatory reporters may still make a voluntary report if they have reasonable cause to believe abuse occurred. That means family members, visitors, and other concerned individuals can report suspected abuse directly to the Department of Public Health. Abuse under the statute includes the willful infliction of injury, unreasonable confinement, intimidation, or punishment that causes physical harm, pain, or mental anguish. Neglect means failing to provide goods or services necessary to avoid physical harm, mental anguish, or mental illness. Mistreatment includes harmful or likely harmful use of medications, treatments, isolation, or physical or chemical restraints. Misappropriation of property involves the deliberate misuse or theft of a resident's belongings, money, or other property. When abuse is suspected, a mandatory reporter generally must make an immediate oral report to a supervisor or facility administrator. The administrator must then immediately notify the Department of Public Health by oral communication, electronic transmission, or fax. A reporter may also bypass a supervisor and report directly to the Department of Public Health if necessary. If the first report is oral, a written report must follow within 48 hours. The written report must include identifying information for the resident, the facility, the reporter, the nature of the suspected abuse, any prior incidents, how the abuse was discovered, and any actions already taken to protect the resident. Once a report is received, the Department of Public Health must investigate within 7 days, or within 24 hours if the resident's health or safety is in immediate danger. Good faith reporters are protected because they are immune from civil and criminal liability for making the report. The statute also prohibits nursing homes, home health agencies, and hospice programs from retaliating against an employee who makes a good faith report or testifies in a related proceeding. When a facility fails to report suspected abuse, it can face fines, corrective action plans, more frequent surveys, and other enforcement measures. Licensed professionals may also face disciplinary action, including suspension or revocation of a license when patient abuse is determined. A nursing home's failure to report can also become powerful evidence in a negligence claim because it may show the facility breached its duty of care and allowed abuse to continue. Families who suspect unreported abuse can file their own report with the Department of Public Health, request medical records and incident reports, and speak with a lawyer or attorney about possible legal action. The guide also notes that the personal injury statute of limitations generally allows 3 years from the date of injury to file a lawsuit, which is why speaking with a lawyer or attorney promptly may help protect important evidence and legal rights. If your loved one may have been harmed by unreported abuse, the law firm Colucci and Marcus, PC can explain your options, and you can contact this law firm at 617-698-6000 or visit 424 Adams Street, number 101, Milton, Massachusetts, 02186, United States.